The Americans with Disabilities Act. Is the ADA civil rights legislation? What activities are covered by the ADA, and who is protected by the ADA? The Americans with Disabilities Act is a federal law that establishes a baseline for protections from discrimination on the basis of disability. Laws in some states provide additional protections from their local statutes. Congress acknowledged that society's accumulated myths and fears about disability and disease are as handicapping as the physical limitations that flow from the actual impairment. That's a quote from Justice Brennan in a Supreme Court case, Arline versus Nassau County in 1987, that really set the standard for how we look at discrimination under the ADA and related statutes. The ADA itself has several titles. The three that are most relevant to you as an individual who is a cancer survivor is going to be Title I, that covers employers with at least 15 full-time equivalent employees. Title II, which covers state and local government. And Title III, which covers places of public accommodations. Privately owned places that are open to the public, movie theaters, restaurants, bowling alleys, and places like that. The ADA's definition of disability is divided into three prongs, three categories. The first prong is a physical or mental impairment that substantially limits one or more major life activities of an individual. That's an actual disability, and we'll discuss it more in a few minutes. The second prong is a record or a history of such an impairment. That covers you if you have no ongoing symptoms, but have a history or a record that somebody is concerned about, and we'll discuss that further as well. The final prong is being regarded as having such an impairment, even if you've never had it, being thought of as a person with a disability. And again, we'll go into that in more detail. So the first definition, a physical or mental impairment that substantially limits a major life activity, raises two questions. What is a major life activity, and when is it substantially limited? So a major life activity might include seeing, hearing, eating, walking, sleeping, breathing, thinking, the operation of major bodily systems and functions such as the immune system, the endocrine system, the digestive system, and normal cell growth. It's not an exhaustive definition. It's an includes but not limited to list. And normal cell growth was included when they amended the ADA specifically to ensure that cancer was covered as a disability. The purpose of prong 2 is to protect you if you have a history of an impairment. You may have no active symptoms, you may be in remission, but someone who is aware that you've had cancer, aware that you've been in chemotherapy, may treat you differently. And this prong is intended to protect you if people treat you differently based on the knowledge that you had cancer, and that differential treatment excludes you or reduces your opportunities or your benefits in the workplace. The purpose of the last definition is when you've actually never had the condition, but people assume for some reason that you have a disability. The classic example in the original legislation was you have a scar or a disfigurement of some sort, and people assume that it limits you in ways that it does not. So there's no substantial limitation. There's no major life activity. There is simply a disfigurement of some sort. And people make assumptions about it. In the context of cancer, that might be because you were seen to be supporting a fundraising event for a cancer program. It may be because you had a mammogram, there was a problem with the image, you got invited back to go for another mammogram, you let work know you were leaving early 2 different days in the same week for a mammogram, and they make assumptions that you must have cancer and that it's problematic. If there are assumptions about your having a disability, if you have a record of a disability, but don't actually have any impacts, you would not be entitled to reasonable accommodations, but you would be entitled to not be discriminated against, not be excluded based on those assumptions.